really pleased that you could join us this morning, and we'll kick off because we've got a fair amount to get through. It's great to see a number of very familiar faces on the call, some new ones too. So just a little bit about Actons and me. My name's Nick Elliott. I'm the head of the Dispute Resolution and Employment Group at Actons. Employment lawyer by day. I'm also going to be joined by Gordon Monaghan, who's head of the dispute resolution team. So he's our special guest speaker in our webinar series that we're doing as an employment team. But Gordon works very closely with us on this kind of work where there's proper courts, as I call it, involved, not just the employment tribunals. So it's great to have him along, and once I shut up midway through the presentation, you get to hear from Gordon. In terms of housekeeping, I think there's a Q&A section as part of Teams, which you're very welcome to pop some questions in as we go. There'll also be a Q&A section at the end. If there are any queries or other technical issues, we have Matt on hand who's making all of this work beautifully, and he can do his best to help you with those if you put those in the chat. I think we're going with microphones off and cameras on if possible. It's nice to see some faces, even though I only get a small selection of them. It's great to see that you're actually there and I'm not just talking to the camera. So without further ado, we'll crack on. The plan for today is to look at a number of different things. So we're going to look at some of the basics around post-termination restrictions and explain what they are, why we think they're important. We're going to look at how we might best draft those, some tips for pulling those together so that they actually work. We're going to look at some alternatives to restrictive covenants, so other things that it might be possible to put in place to help protect your business at the point employees might be leaving or after they've left. And then Gordon, as you say, is going to talk about how we might actually enforce those restrictions. So it's great if we've got them, but what do we actually do with them to actually get that protection that you're looking for. So that's the general plan. It will be a bit of an interactive session, so we've got a few polls as we go so that we can get a bit of feedback from you and share that with each other through that system, through Teams, which is great. But the other thing I like to do, if you've been to any of the rest of our sessions, is actually put some of this in context. So it's all great, from a legal perspective to talk about some of this technical stuff, but why does it matter? What are we seeing at the minute that makes this important? Well, I don't think you have to go too far to see that we have a very active job market at the minute. Salary pressures are high. There's a shortage of talent, and that tends to mean that people are moving, and with them goes information. Goes those kind of legitimate business interests that you might be wanting to protect as part of your business. We're also seeing a certain amount of economic downturn, which in our experience also leads to employees doing naughty things, as I describe them. So potentially stealing confidential information, pricing, trade secrets, that kind of thing, and thinking that they might do better on their own, for example, and setting up in competition with your business, or that actually they get tempted by going elsewhere and taking some of that information with them. So it's an interesting time from that, and we're certainly seeing some of that happening. In terms of the damage that can do to your business, clearly confidential information, strategic plans, customer and client details are really key to how you run your business, run your organization. And it may be that those employees are looking to use those for the benefit of themselves or another employer. And that might well do serious harm to your business, depending on what information it is, what individual is going. And I guess that's a key part of the analysis often when it comes to Gordon's part of this, which is whether you actually want to enforce these restrictions, because the damage, the financial damage that an individual can cause is often a key factor in that. And again, Gordon will touch on that a bit later. So that's the context. We're now going to have a kind of a gauge the room type polling session, which I think Matt will make appear on our screen shortly. And this is really just to gauge where people are at actually with restrictive covenants. So I think the first one is whether you currently have covenants in your employment contracts as a business. So hopefully the poll is popping up on screen for you. And it's a really tricky yes, no answer. So do you have them in your employment contracts at the minute or not? And then hopefully we'll all be able to see the results of that. So I'm not sure we've quite got all the responses yet, so we'll just give it a second. But it looks like a fairly overwhelming response to the positive. So that's an interesting stat to start with. 100% of the people who have responded do have them in the contract, so that's interesting. If we move on to the next one. Slightly different question. So do we think that the covenants, the restrictive covenants, are actually worth including in the contract? Now, I guess you might say if you've got them there, the answer would be yes, but you may have them there and think actually they're not really worth including. So let's see. Yeah, so that's interesting. So nearly a third of people saying no, they're not worth it because they're too expensive to enforce, and we'll certainly come on to that. And 7% because they don't work. And again, that I think is a perception that a lot of people have. And again, hopefully we can address that. Next question is, have you ever tried to enforce restrictive covenants against an employee? So we might have them in the contract, but actually, have we ever actually done anything about it? Yeah, so that's interesting. So roughly a third, 2/3 on that one. So that's interesting too. And then finally, we're just gauging a little bit here. Do you use any alternative strategies to protect your business interests or prevent employees joining competitors? If so, what? So I think if you want to pop that in the chat, if there's anything else that you might include or encourage employees to stay and not leave. Now, I appreciate that's quite a general one, and we'll come and touch on some of those, but it'd be interesting if anybody does have anything novel or unusual that they're willing to share, pop it in the chat. That would be great. And we can have a look at that as we go. I'm going to keep going on the basis that we've got lots to get through. Thank you for that. So the basics around restrictive covenants, what are we actually talking about here, and why are they important? So part of the key to this really is that there are certain things that you could do about an employee leaving and taking confidential information or that kind of thing with them, but the key protection that you have is actually something written in the contract in a contractual way. So actually something set out expressly to reflect what the parties had agreed as part of that covenant, and that allows you to tailor it to your business and to the role that person's doing. So it gives you a much more specific protection. You can then seek to limit what that employee does after they leave you. And that's, of course, all designed to help protect your business. They're clearly also a deterrent, and I think that feeds into some of the polling answers there, where we might have them in. We might not be that sure that we would ever do anything about it in reality, but we do have them in, and they can act as a deterrent, both for employees joining competitors, but also potentially for new employers who are thinking, oh, these people have restrictive covenants in their contract. That's potentially a problem, particularly as the old employer may well have claims against the new employer, for example, for breaching or inducing a breach of contract. And again, Gordon will come on to that, no doubt touch on that a bit later on, but that's certainly something that features in the mind of a new employer. And then I suppose the key part to get across here is that there's a tension in all of this that the courts grapple with, and that really is that the courts want employees to be able to work. So preventing them from going to a new job does restrain trade, as they might describe it. And clearly they want people to be able to move jobs. That's entirely fine, and earn a living. But at the same time, and they kind of bash up against each other, I always think, is the understandable desire of businesses to protect their what we call legitimate business interests. And those two things sort of bash up together, and the courts are kind of grappling with that and trying to work out, okay, well, what's appropriate, what's not. But the position that they take is that effectively any kind of restriction is void unless you can show that it's protecting a legitimate business interest, and it doesn't go any further than is reasonably necessary to do that. So it's not more restrictive than it needs to be. So that's the key sort of factor to keep in mind with all of this when we're analysing how we might pull these clauses together and whether they would work or not. Now, legitimate business interests can include a number of different things, and they're set out on the slide there. Trade connections with customer suppliers, confidential information, but also things like protecting the stability of the workforce. So not losing employees because an ex-employee has pinched them, for example. And then another key point really is that the question of whether a restriction is reasonable is considered at the point that the restrictive covenant is entered into, so the point at which generally your employee signs an employment contract that contains them. And that usually is at the beginning of someone's employment. So it's worth remembering, again, we'll touch on it a little bit later, that if people are promoted or change roles, it's important to keep those restrictions updated to fit with that promoted role or different role, because it may be the case that actually that covenant doesn't work anymore for the new position. The other thing that often comes up is where people are told about restrictive covenants, and they've heard about them in terms of how long they can last, how long the restriction might be, for 2 or 3 years, and we often get clients thinking, oh yes, that would be great, we'd love to protect for that long. Generally speaking, that's in the commercial world where there are business sales happening or something along those lines. In the employment sphere, 12 months is generally the absolute maximum that that anybody will be able to enforce because of that restraint of trade point, not preventing employees from working essentially for that kind of period of time. And we'll touch on why that is. But generally speaking, in the employment field, it's a shorter period of time. Then in terms of the types of restrictions that we might put in place, this slide just covers those, and hopefully you'll be familiar with some of them. So non-solicitation is essentially not pinching customers and clients from your old employer. Non-dealing is not providing services to those customers or clients that you perhaps worked with previously. And then we have non-poaching and non-employment, which is essentially not pinching employees or employing them, even if actually you didn't pinch them. You could have a restriction on them being employed in the new business too. And then non-competition is pretty obvious, not joining a rival employer or setting up a competing business. So they're generally the types of restrictions that we see and that seek to protect those different scenarios that might come about where you want to prevent your ex-employee doing certain things. In terms of sort of tips for, well, they're partly drafting, partly actually linked to what Gordon will talk about in terms of enforceability, but actually having the clauses in the contract in the first place sounds like an incredibly obvious point, but the number of times we have clients come to us with a situation where someone's left, they've taken information with them, employees with them to a new employer, and they're seeking to do something about that, but actually they're very limited by the fact that there are no restrictive covenants in the contract in the first place. That's actually quite common, and it does really limit what we can actually do to deal with that situation. It is possible to have them in a separate document as long as the employees signed up to that and we're clear that everybody's agreed, but generally speaking they will be in people's employment contracts. And again, the poll earlier suggests that they are at least there in some form in most of the attendees contracts that they're working with. Also making sure that it's signed by the employee. I guess this is a shout for the HR admin functions within your businesses. Just being on top of that administrative side, making sure that actually employees have signed up to the terms is really, really important. Again, it's a really basic point, but quite often we'll have situations where, you know, the client is saying to us, well, yeah, this was the contract that we gave them, but we didn't ever get it back signed. And it's not fatal to our arguments with regards to the restrictive covenants, but actually it doesn't help, because it does give a little chink of light for the other side to say, well, actually, you know, we didn't accept those, we didn't agree those, and they weren't the restrictions that applied to this individual. So that's really important. And as I said earlier, keeping these covenants up to date at the point where there's a role change, either promotion or some other change of role, is really important too. And if there is a change during employment, just remembering that there needs to be something called consideration for agreeing to those restrictions, which generally is giving something in return for them signing up to the new restrictions. That might be money, it might be extra holiday, that kind of thing. So that's worth just being aware of too. And then, of course, the key one that comes up very often when we're helping clients draft these kind of clauses is, how long can we restrict somebody from doing something? And generally that's, how long can we prevent somebody from joining a competitor? That tends to be the most common one. And that usually is broken down into a period of time, 3, 6, 9, 12 months even. The key there, and I'll give a really good example of how best to approach this in a second, is that you're usually looking at the business interest that you're trying to protect, the person, the role that the person is doing, and things like, how long would it take for a replacement to come in and secure client relationships so that they were protected, and therefore it was reasonable to keep the ex-employee out of circulation for a period of time in order for the replacement to do that. How long was the design cycle for the engineer, let's say, that was design engineer that was designing something? How long was that design cycle? How long could you legitimately say that you needed to protect that business interest for a certain amount of time? Or, for example, how long the shelf life of confidential information, pricing information, let's say, might be. If you're actually changing that information on a regular basis and that ex-employee is out of the business anymore, is not in the business anymore, they're out of the business, then actually that information is probably out of date, for example. So that's worth keeping in mind. And then things like geographical restriction, again, often comes up. Could you have a global restriction where you're preventing somebody from joining a competitor anywhere in the world? Do you limit that to a certain mile radius around your offices or where you operate? I think the example that often was used in textbooks was hairdressers. You know, you couldn't go join another hairdresser within a certain range because you would pinch the clients within that geographical limit. And just to sort of bring that to life a little bit, this was a case that I was involved in. I checked last night. Actually, it was 15 years ago, I think, when I was a trainee solicitor, and we acted for Dyson. And we'd helped them put their restrictive covenants together. So they had them in an employee's contract who was the chief design engineer working on what was then the new handheld Dyson. So they hadn't released that to the market yet, and they were working on it, and it obviously was super top secret. So this chief design engineer decided that he wanted to take some time out, and he explained to his boss that he was heading up north to do a bit of study and spend some time with his family. He resigned, served out his notice, and left. And then they discovered that actually he was lying, and he'd gone to Black & Decker. Now, at the time, for all of you vacuum cleaner experts, Black & Decker were the leading handheld manufacturer of vacuum cleaners for the Dustbuster. And Dyson were understandably very worried that he was going to take their cyclonic technology, I became an expert in that, and put it into the Dustbuster and actually steal a march on Dyson. So they were incredibly concerned about this and not very happy that he'd lied to them, understandably. So they sought to enforce the restrictions that he had in his employment contract, and actually he had a global restriction on him joining a competitor, and that was for a period of 12 months, which seemed very extreme, certainly to me as a trainee solicitor at the time, but actually it played out quite nicely for Dyson, and they were actually able to enforce that. and I'll explain why that was. So we took that all the way to the Royal Courts of Justice in London. It was a slightly dodgy start on the basis that the judge that we had didn't know what a vacuum cleaner was. He clearly had somebody else that did the cleaning for him, I guess. But that was a slight worry, so we had to show him some vacuum cleaners so he understood what they were all about. We also learned that not all vacuum cleaners are Hoovers. The Dyson guys were very unhappy if you ever mentioned Hoover, because of course that's a brand name. So we had to be careful on that. But the key legal principles, other than that fun that we had, were that actually that 12-month restriction was enforceable because the design cycle for the handheld product that they were making was 12 months. And at the point they released it to market, Black & Decker and probably some other people would have gone and bought that item, taken it to pieces, worked out how it worked, and actually that protection wouldn't have been appropriate at that point because that that information, that product would have been out there. But what the court said was until that design cycle was complete and the product was released, they had a legitimate business interest to protect, and they were able to evidence, and again Gordon will talk about evidence later, but they were able to evidence that that was the design cycle, that was how long it would take, and therefore it was an appropriate restriction. Likewise, they talked a lot in court about how truly global Dyson's business was, and that actually there were competitors all over the world that this employee could go to and cause them significant damage, and actually they were able to enforce that global restriction too. So hopefully that's a useful example of how it's really important to be able to analyze the restriction or fit the restriction to the situation for the employee. Now, actually, that takes a lot of work. I'm working with a client at the minute, actually, where they're actually doing this, and they want to tailor these restrictions to improve the chances that they're enforceable to specific categories of employees, maybe even to individual employees who are really, really important, and actually, give themselves the best chance of those restrictions being enforceable because they've been through that process and tailored them really carefully. So hopefully the Dyson examples are a useful one and it'll stick in your mind. So I also mentioned that we talk about some alternatives to restrictive covenants. So given that a number of us have said, do they actually work anyway? Perhaps there are some other options that we might look at as well. And these tend to be the ones that we've seen. So the first three, I suppose, are money that is held for a period of time in order that the employee is incentivized to stick around with their current employer, because if they leave, they might lose that money, or shares in the case of long-term incentive plans. The other one we see is this repayment of training costs, and I'll touch on that a bit more. The deferred bonus or remuneration tends to be very common in financial services and listed companies, and it's designed to ensure that kind of retention of key people. And as I say, the downside for them leaving is that they would lose that money if they go before that's due. It's often cash or shares, and sometimes within those schemes there'll be what you probably have heard of before, good leaver, bad leaver clauses. So the circumstances in which those people are leaving will determine whether they get that cash, whether they get those shares or not, or in fact what the value of those might be should they go. That says linked in to future performance. That's my fascination with LinkedIn. It should be linked to future performance. So again, often there's performance related element to some of this. And again, we're also seeing within those schemes actually some restrictive covenants being built into those plans themselves. So not only are they themselves potentially a type of restriction, but that there are specific express restrictions being built into those schemes too. I think more commonly, certainly within our client base, are clauses that seek to recover training costs that are paid to train an employee by the employer, and then are repayable by the employee should they leave within a certain timescale or before a certain date. Often that's a sort of sliding scale, so the longer you stay, the less of that training cost that you repay. And again, we've even had some clients looking at this in relation to the apprenticeship levy, which you can't treat in this way. But actually, the amount of money that people are investing in training, if there are other elements that the employer is funding, trying to build clauses around those elements to help incentivize those people who are being trained through the levy to stay as well, because of the significant investment in people that the employers are making, but also because of the number of people that are moving at the minute, and the salary pressure, as I said at the outset, really trying to focus on, okay, well, if we're going to invest in you, we want you to stick around, you know, and you know, we're going to look at recovering some of the cost of that if you don't. So that's a pretty common one. Part of the reason for mentioning these as part of this session is to give some ideas around how they might work, or other things that you might think about, but also because there is a risk, and it's just to flag that risk, that the courts will look at those kinds of what are often called atypical restrictions in a similar way to normal restrictive covenants. So they'll look at it and say, is this a restraint of trade? Are they reasonable? And again, as Gordon will touch on, the court will always look at this on a case-by-case basis. It will always be the facts that apply at the time. And certainly if you are building any of those kind of atypical restrictions in, it's worth taking advice on that as well, so that you structure them in the best possible way for them to be enforceable too. And then I think Gordon is going to take control of the slide deck.
Yes.
And,
thank you, Nick. So just by way of introduction, my name's Gordon Monaghan, and I head the dispute resolution team here at Actons. So I deal with a wide range of disputes, often shareholder disputes and other contractual disputes, but certainly restrictive covenants are very much my bread and butter, and I come across them on a reasonably regular basis, it's fair to say. So you followed Nick's advice, and we have some well-drafted and reasonable and incorporated restrictive covenants within the contract of employment. The question then arises, well, how do you know if they're being breached, and what can you do? So the most obvious answer, as the slide heading suggests, is in essence to start monitoring your employees. The issue with that is that it is a very complex area. If an employer goes too far, potentially they can be committing a criminal offence. So it is important that the right balance is struck. The best starting point for this is the Information Commissioner's Office Employment Practices Code, and Part 3 deals with the monitoring at work. And like a lot of data protection matters, it encourages that the data subject, in this case the employee, should have knowledge, and consent is a key thing in data protection matters. So they should have the knowledge and consent to monitoring. And in order to do that, again, the Employment Practice Code recommends that employers carry out impact assessments, so as to basically if and how the carrying out of the monitoring is necessary, and what impact will it have in relation to the employees. So it's really key that that's documented in case a dispute arises. And also, and again, speaking to where speaking to Nick comes in, is make sure you have the right policies in place. So obviously a comprehensive internet, comprehensive email, comprehensive telephone policy is in place in relation to those particular matters. In terms of slightly more practical steps, speaking anecdotally, avoid BYOD if at all possible. For those of you not familiar with that expression, it's bring your own device matters, and basically applies or is applicable where the employee's own personal mobile or own personal web computer or laptop has business data within it. Now, the reason why I say that is I appreciate there is a cost. This is a cost issue to the business in order to pay for more laptops and mobile phones, but that level of complexity that I mentioned a slide ago is magnified and multiplied when dealing with BYOD situations, and it can get incredibly complex and therefore add to the cost of potential enforcement further down the line. So that's just one practical point. The next thing is ensure customers deal regularly with a number of employees. So again, it's a fairly obvious thing, but if you can actually build it up so that they're dealing with a number of employees, then their loyalty is hopefully going to be to the business rather than one individual employee. And it also means that it's more difficult for a single employee to start covertly dealing with them and saying, look, I'm going to be leaving to join a competitor. Will you come with me, and so on. So that again is a fairly obvious and easy way to try and spread customers' dealings around, if at all possible. Another slightly random one is ensure employee takes proper holidays. So obviously it can be badged up that this is in the best interests of the employees' well-beings, but you would be surprised at the amount of illicit behaviour that can be discovered as a result of employees taking holidays, and particularly a 10-day period. And indeed, the Financial Services Authority recommend that all of its organisations that their employees take at least a 10-day period, and part of that stems back to a historic matter where a trader basically managed to steal 50 billion euros worth of money, and it transpired in the course of the investigation that he hadn't taken a holiday for 2 years because he was paranoid that people would have access to his trading books and would be able to discover the in essence the siphoning that he was doing. So again, a sort of practical approach to deal with it. And then an even more random one is consider location of photocopiers and monitoring use. Again, it's not unusual, certainly at law firms, that any photocopying is allocated to a client matter, and people have to input who is undertaking the photocopiers. If they are in a prominent position, it is slightly more difficult for the employee to go and hide and start taking lots of copies of hard copies of confidential information towards the end of their employment. Also, if you're monitoring the use and you have certainly senior individuals who perhaps don't use the photocopier as often as other people, it might start raising questions as to, well, why, particularly if they're serving their notice period, why have they suddenly started taking significant amount of photocopying? So those are some of the practical steps. So you've been monitoring them. You then discover some potential suspect activity or something that might amount to a breach of the restrictive covenants. The key thing here is to act quickly. It really is an essential time to act quickly. And as I always say to clients, courts do not move quickly, except when it comes to interim injunctions, and as a result, it expects the parties to move quickly. And as I say, if you don't, you can potentially, so you can have the best restrictive covenants in the world, you can have the best evidence, which again we'll go on to, in the world, but if you delay and take too long in deciding whether or not to proceed with an injunction, you can potentially be prevented from obtaining that injunction. You also need to, as part of that acting quickly, is you need to collate evidence, which we'll talk about in a bit more detail in a couple of slides' time. But part of that will be involving your IT department. emails, again, which we'll talk about in a moment, are really quite key. And if you've got a strong IT department, a large IT department, get them involved, get them scouring the emails within the employee's business account, and that's quite key, going back to what we've talked about data protection. But it's important to get them involved. You may want to outsource it to forensic IT services, because it is amazing, as I say, what a forensic IT consultant can dig out from what you had thought were deleted items, the metadata that they can drill down to. It's quite spectacular. So that is worth some thinking about that. But a bit of interaction. So I mentioned about delay. So we'll have a bit of interaction now, and in a moment I'll ask you to have a vote on this. So this is actually based on a real life case that the Court of Appeal very recently has decided. It was based on a 12-month restricted period for various covenants, but the particular one that we'll be focusing on is a non-compete. So the sort of the biggest, the top of the range restrictive covenant. So these are it relates to a 12-month non-compete. So the chronology was on the 23rd of July, the employee resigned. And then a month later, the employee's employment, served out the month notice period, came to an end. For what it's worth, the employee was put on garden leave on the 6th of August. On the 1st of September, so just over a week later, the employee commenced employment at a competitor, and literally the very next day was when the employer discovered this fact and that there had been a breach. Presumably, they then approached their solicitors, and on the 20th of September, a letter before action was sent by their solicitors to the employee. And then a month later, on the 21st of October, court proceedings were issued seeking an interim injunction. And on the 5th of November was the hearing. So I just want you to sort of bear that timescale in mind as we move on. In essence, the key dates, I would say, are really discovery of the breach on the 2nd of September and the date that the court proceedings were being issued 6 or 7 weeks later. So if Matt can hopefully magic up the poll. So in your opinion, you're sat on the Court of Appeal, was there a delay which was sufficient to dismiss an application for an interim injunction? And you've got 3 options here. You've got yes, there was a delay, no, there was no significant delay, or there's also not sure. So if everybody wants to vote now. Wow. that is, I'll give it a couple more minutes, but certainly when it flashed up, it was bang on a third. And funnily enough, if we call that more or less a third, I think I was going to say, I think there's an argument, and you'll see that all 3 are potentially correct. I would say potentially not sure is perhaps the strongest. What actually happened was, for those of you that are interested, is that at first instance, the judge at first instance did say that yes, there's been a delay, and said that therefore I'm going to dismiss this application. It was then appealed to the Court of Appeal, and one of the Lord Justices also agreed with the judge in first instance and said yes, that is too long a delay. 6-7 weeks is too long. Interestingly, though, the 2 other, because it's a panel of 3 at the Court of Appeal, the Lady Justice and Lord Justice gave fairly coded or certainly tepid support to say, well, no, actually, come on. let's be real, we don't want solicitors running off at very quick notice. Part of the reason, which we don't know exactly, is probably there was without prejudice communications in an attempt to resolve it. As it happened, the Court of Appeal managed to dismiss it on other grounds, so which is why the two shall we say, supportive judges didn't have to come out that much stronger because they dismissed it on other grounds. But I think it really does demonstrate that point that I said about acting quickly. For what it's worth, I think I think it is too harsh. I think that is not an unreasonable timescale. And as I say, I would be sort of supporting the two judges in the Court of Appeal and not the judge at first instance. But it does show you that it is a real judgment call. And if you're starting to get to 6 to 7 weeks after discovery of the breach, you may be disqualified, or you may be debarred from obtaining that injunction. So moving on. So I mentioned a moment ago that you've discovered the breach and you've got to collate the evidence. The emails, as I said a moment ago, are really key. The employee sent item for their, again, business address is key, and you'd be surprised at what can come up in relation to that. Another way of often getting good evidence is where the customers, if this tends to be after they've moved on and are with perhaps the competitor, is if customers send just use the auto predict email address filler, and they tend to send it to the old email address of the employee, in other words, your email address. And if you monitor the ex-employee's inbox, it might be that something like this can come to light after they've left, that basically a customer makes a mistake that's gone with them, and that is good evidence that clearly they have solicited or are dealing with the customers. So you can also look at LinkedIn. LinkedIn, I think it's good in terms of getting knowledge of as to what's going on, and certainly in relation to non-compete restrictive covenants. If you get an ex-employee saying, yes, you know, I'm now working at this competitor and it's on LinkedIn, that's evidence. Where I think LinkedIn is not so good and clients sometimes get a bit frustrated is it's not very good in terms of evidence of soliciting customers, because there is that element of social crossover, and merely by saying I've started work isn't the same as saying I'm soliciting work, or by saying, hi, hope you're doing well, and how's the kids type thing, or a message on that. That in itself may not be strong enough evidence. So I think it's worth monitoring LinkedIn. It's certainly worth for a knowledge perspective, but from an evidence, it's sort of in a bit of a grey area. Witness statements. So if you can't get documents, then us litigators go to our witness statements. Now, where they can be useful is if you have a poaching or non-employment. So if the ex-employee approaches one of your current employees and says, do you want to come and work, and your current employee turns them down, then that would clearly be they've shown loyalty. They might be prepared to provide a witness statement to show that actually that ex-employee has approached them and has offered them a job, and so on. So from a poaching or a non-employment restrictive covenant, the witness statements of current employees can be beneficial. In relation to customers, even if they have shown loyalty or they've notified you that actually the ex-employee has approached them and has sought to solicit from them, and again, it's a good way of gathering the knowledge is actually through a customer who through loyalty has told you. there is a question of, do you really want to rely on them in essence to go to litigation and potentially dirty washing and all the connotations that comes with that, in terms of getting them to commit to providing a witness statement and sitting down with lawyers and going through that? It depends on the strength of relationship you have with that customer. If we're being honest, it might be that yes, you are. The other thing is are they going to be willing to sit down and spend time talking to lawyers to give a witness statement and so on, and potentially, and we'll come on to it, it's rare, but potentially give evidence at a final hearing many months down the line. That is it's pretty unlikely. So I've kind of put customers question mark, that I do tend to find anecdotally it's pretty rare that customers are willing to get involved in relation to a restrictive covenant dispute. So briefly touching on, as I say, we're getting on to the minutiae a little bit of the procedure, but what you'd basically do is you've been monitoring your employees, you've found the suspect activity, you've collated some evidence, hopefully you've already approached us or your solicitors, but approached Actons and said, right, this is the situation. What we would then be looking at is a letter before action that's sent to the employee, and it's in essence asking for an undertaking for them to cease trading, to cease breaching their restrictive covenants, whatever they may be, and for them to sign it. What and again, you would often ask this, as I've said, normally in letters before actions in standard contractual disputes, you might be saying, well, we want a response within 21 days, 28 days. This is the sort of one occasion that the courts do say, okay, 7 days, maybe even 48 hours is appropriate for a response in order for that to be provided. There is the other option of maybe you don't want an undertaking, but you just want a shot across the bows and you'll monitor the situation. And again, that puts them on notice that you're aware that they're acting potentially unlawfully, but you're going to continue to monitor the situation and you reserve the right to issue proceedings without further notice. So Nick, you can also think about a letter before action to the new employer, and Nick touched on this on one of his slides about inducing a breach of contract. So the first thing, in order to induce a breach of contract, the first thing you have to do is put them on notice and let them know that you have or that the ex-employee owes you still owes you obligations and the nature of those obligations. The reason why I put a question mark, I don't think it's automatic sometimes, because I think there can be situations where the threat of proceedings against an individual employee is they can be thinking, I can't afford that, I can't afford this, and actually we've got the deeper pockets, and therefore the threat of just dealing with the employee is sufficient for them to make them change their mind. The downside of contacting the new employer is they may fall in behind their new employee and say, yeah, we're paying for this, and actually then it totally, in terms of who's got the deeper pockets, it can totally sometimes reverse, and unfortunately that is often a factor in litigation as to who has the deepest pockets. I think if it's sufficiently serious, I would be thinking about a letter before action to the new employer, but it is a bit of a judgment call, and I wouldn't always recommend it all of the time. So the question is then, okay, you get either, so you sent the letter before action and either you get no response, which again isn't that unusual, or you get a refusal, a downright refusal to sign. And it's basically at this stage that you need to decide whether to press the button and issue court proceedings. Certainly that's what you'd be doing in real life. And in real life, what you would actually be doing is we would be instructing a specialist barrister, probably in London, and you'd be taking both our advice, the barrister's advice, as to the prospects of success and weighing that against the commercial business needs of the company and where that goes. However, you've been listening to Nick and I for getting on for 50 minutes now, so I'm sure you're all experts now in relation to restrictive covenants. So I think we're just going to have a quick fire round of real life cases that have gone before the courts, and all I want you to do is for each one is to say whether or not it's enforceable or not enforceable, and they all relate to 12-month non-compete. So that first one there that you've got, so you've got a 12-month non-compete for a technical director of a company manufacturer sterilizing units for hospitals. Do you think that is enforceable or not enforceable? Okay. Okay, wait for a few more. Okay, so I think that's nearly everyone, and we've got sort of 3/4 saying enforceable. They sort of or the 70%. As it happens, yes, that is what the court found. The court basically concluded that the employee had access to all of the employer's confidential information, and also the period was reasonable in light of the time it took for development of new products, which again sort of links back to Nick's example about Dyson. Of they basically said, well, look, that's the shelf life. There's a 12-month lead-in time, so therefore it should be enforceable. So if we move on to the next one, is again a 12-month non-compete for an employee of a state agent from working for a competitor within a 5-mile radius. Do we think that is enforceable or not enforceable? Wait for a few more responses. And I think so. The overwhelming majority thought not enforceable. I think the training's going well because that's exactly what the court decided, is that they felt that the employer's legitimate interests were sufficiently protected by non-solicitation. So in other words, they said, look, you don't need the non-compete. The non-solicitation is sufficient to protect your legitimate business interest, as well as the confidentiality clauses. And they went on to say that 12 months was in any event excessive to protect against the misuse of confidential information, which they felt was limited anyway. So again, that's we're doing well here. So if we move on to the next one, so a 12-month non-compete for a software developer and seller. Do we think that is enforceable or not enforceable? Few more responses still to come in. There we go. Okay, so we've got a 2/3, 1/3 split in relation to this that think it's unenforceable. So this is the first one that you guys have got wrong. So this was unenforceable. And basically what the court found was that there was the absence of a territorial limit. The definition of market was too wide in that field of computer systems was the definition. And then there was the absence of an equivalent covenant that restricted the employee from entering into competition on her own account. Now, you might say, well, hold on, I didn't know all of that information when I gave the judgment. But I hope that's trying to give you an idea of It all depends on the facts, and so I know we keep banging on about it as lawyers, but the facts and circumstances of each case really does impact. We can't just say, well, 12 months is fine or 6 months is fine. It really does depend on the facts and circumstances of each case, and actually what does the drafting say, and how does it deal with it? So one more very quickly, we'll go on to the next one. So this is a 12-month non-compete for a managing director of an insurance broker specializing in services for social housing. What do we think in relation to that? Enforceable or not enforceable? Couple more still to come in, but it's looking fairly even. I think certainly on mine it's showing just a majority saying not enforceable. This was one where it was enforceable. There we go, 50-50. Are we going to get one more to take it? Now that I've said it, it's not. Sorry, I beg your pardon. This was enforceable, as the employee had access to confidential information, including pricing and financial information, with a shelf life of more than 1 year. Again, that shelf life of how quickly does that information remain confidential. And the court also felt, the second thing that supported it is they felt that a narrower covenant would have been difficult to have police. So hopefully that gives you some examples of it does really depend on the facts and circumstances in relation to each matter. So you've kind of basically you've collected all the information, you've sent out the letter before action, and you've taken the view, okay, we're going to push the button and we're going to issue court proceedings. So what exactly does that entail? The first thing to say, and we kind of touched on this in the background throughout the course of these proceedings, but the key thing to bear in mind here is that the primary remedy that you're seeking with restrictive covenants is an injunction. So in other words, an order of the court that they should stop breaching their contractual provisions. It's not the same as most standard contractual disputes that might be a debt matter or another breach of contract where you're looking at a monetary damages claim. You can have damages claims, and we'll come on to that in a moment. You can include it as well, but the primary remedy is that you're looking for an injunction and an order of the court stopping the errant ex-employee from breaching. It will require a detailed witness statement from you or from somebody within the business. And the reason why I say that is, again, we'll come on to the legal costs in a moment, but it's really just to make the point that it will need somebody senior, almost certainly director level within the business to give the detailed statement. Is that it will require management time, is somebody's going to have to sit down with us for us to go through what is the market position, what did the employee do, what access did they have, who did they deal with, who are they working with now, what do they do, what's their position in the marketplace. All these sorts of things are the types of things that will be relevant to the potential court proceedings and need to be dealt with. And in terms of the court issue fee, again, we'll talk about costs in a moment. But if we're talking, because you claim the injunction and often you double up and claim damages as well, is if this is a business critical matter, then the potential damages that the business might be facing could be fairly significant indeed. And if they exceed £200,000, then the court fee, anything over £200,000 attracts a court fee of £10,000. Basically, anything up to that, it's 5%. So it gives you an idea that if you are suffering significant costs or say a business critical issue and your damages are likely to be substantial, you will be paying a significant court fee over and above the solicitor's fees and barrister's fees. So what you will then get is, as I say, the return date or the interim hearing date will be within a matter of days. As I said at the start of this talk, it's the one time that the court moves quickly. Don't expect this in any other form of litigation that you'll get a court hearing within days. You're normally looking at months and so on. And it is dealt. It's what's we call it a papers thing. In other words, what that means is that yes, the barrister will stand up and talk and will make submissions, but there'll be no cross-examination of the witnesses. So while the business, you potentially have given a detailed witness statement, nobody will be cross-examined, and the other side won't be cross-examined. It's all based on the legal arguments and the papers that have been dealt with. And then if you're successful, you will get an interim injunction. Now, what that normally means is in essence an order from the court saying to the employee that they must stop acting in breach and that they must abide by their contractual obligations. It is interim. The reason, so it's not at that stage a permanent breach, because because it is as I say, a very brief overview from the court's perspective, and what the court says, and this leads on to the point there about cross undertaking as to damages. Because it is a brief view, the price of that is that the court basically says that in the event that we get to a full hearing later on, and the court subsequently, when it considers all the evidence and you have the all the witnesses, they're cross-examined and we have full disclosure and everything else, and if the court then subsequently decides actually the court shouldn't have granted the interim injunction, is that the applicant has to basically compensate the other side, the defendant in this scenario, for any loss that they might have suffered during that interim period. So what the court says is you, as the applicant, have to give a cross undertaking as to damages. So you have to say to the court, in the event that it's subsequently decided that it was wrong, that an interim injunction is wrongfully granted, is we will make good to the defendant any damages that they might have suffered. Now, what that cross undertaking might amount to depends on the size of your business, if I'm being blunt. If you have if your business is very large and is a cash rich business, it might be the case that simply all you need to do is attach some statutory accounts or the latest management accounts demonstrating what your balance and what's held at the bank, in essence, of do you have lots of money at the bank. If, on the other hand, you're not in that fortunate situation to be a big PLC or a very cash-rich business, what the courts might ask for is what's known as fortification of the cross undertaking, and this basically may amount to a payment into court of an amount that might represent a realistic estimate of the damages that might be suffered. So it is something worth bearing in mind at a relatively early stage when you're considering court proceedings of, look, have we got the money? What will our position be in relation to a cross undertaking to damages? Have we got strong financial accounts that have been filed at Companies House, or are we in difficulty? And if so, is there a parent co? Is there somebody else? Is somebody personally prepared to guarantee it? Whereabouts does that sit in relation to it? So I hope that's cross undertaking and damages are a bit hard to put it crudely to get your head round. In essence, I think a crude way of putting it is that the court asks for an insurance policy in case it makes a wrong decision, but it asks you to underwrite that insurance policy, is basically a fairly crude way of putting the cross undertaking of damages. But let's say you fulfill the cross undertaking damages, you get your injunction, and you get a costs order. And again, depending on the outcome of the interim injunction, the general rule in all litigation is that the starting point certainly is that the unsuccessful party pays a proportion of the successful party's costs. And so therefore, if you've been successful in getting your interim injunction, there's a good chance that the defendant will have to pay a significant proportion. We generally say somewhere between 50 to 70% is a rough ballpark of your costs. However, the flip side of that is if you're not successful and the court says no, that dismisses your application, is that you will have to pay a proportion of the defendants, the ex-employees' legal costs, which probably are going to be of a similar proportion to your own. The final thing to note, and I mentioned it, is that often you have the interim hearing, you get your injunction. I would say 8 out of 10 times that concludes the matter, and essentially, certainly if it's dismissed, is you don't normally proceed with any further. If you're unsuccessful, you don't take it further. Likewise, if you're successful, is often the defendants will back down and say, okay, we'll abide by, if it's another 12 months, if it's a 12-month non-compete, we won't take it any further. Occasionally, though, and what the courts allow for is that it says, well, okay, we've had the interim injunction, let's now have a final hearing, so that we do have full disclosure, that there is cross-examination of witnesses, and that will be a few months down the line, but it will be expedited, so that you have to be prepared that potentially you may be having to go to a final hearing on this, which is a full trial, but in a very condensed period of time. So again, it is an occasion where the courts act quickly. Normally, for a final hearing, we say about 18 months from issue, but you could have a final hearing within 3 months from the interim injunction hearing stage. So that is something that can happen. I will briefly mention the costs, because it is always something that people are interested in. Clearly, if it's just an initial letter, it's only a few hours of my very reasonable rate, so it's not going to be anything too excessive. In order to get to an interim injunction hearing stage, you're looking, the sort of standard quote is generally 20 to 30k plus VAT, plus that 10k issue fee that I mentioned earlier. The 20 to 30k generally, or the 30k is normally includes the barrister's fees as well. But you're looking at a sizable sum. And again, going back to that cost order, is yes, you might recover. If we're successful, we might recover. We should recover a proportion, but we also have to bear in mind that if unsuccessful, we might be liable for a proportion on the other side. I mentioned forensic IT services, who, as I say, are a bit like forensic accountants in my experience, is that if you think lawyers charge a lot, wait until you see the bill from the forensic IT services or the forensic accountants. They tend to be quite expensive, and that's outside that initial estimate. If you need to involve them, they can be expensive. And I mentioned about the risks of an adverse costs order. If it goes all the way to a final hearing, I've put 100k there, but realistically, you're looking at 200k, as I say. But it is very, very rare that it will ever get that far. So, having sort of said, oh, it's quite costly, and again, it links in with Nick's initial thing, and I think there was a reasonable percentage that said, well, they're too expensive to enforce. It is why bother with restrictive covenants? Well, first and foremost, if you haven't got the clauses in, you don't have a leg to stand on. So I think, as I put there, you've got clauses improved negotiating position is they give you at least a platform in which to threaten the other side. And it is, as in most cases, when it comes to litigation, there is an element of, well, let's just, what can we do to strengthen our negotiating position? Second thing is it can be business critical, as again it was touched on by Nick. These, if one of your employees is going to get up and take your whole business away, it may well be the case that it's worthwhile throwing the kitchen sink at this, because if you're taking a huge customer that's worth hundreds of thousands of pounds to your business, it can be really quite critical. And again, if you haven't got it, then you can't do anything about it. The other reason why you might want to take action is it sets examples to other employees, to your existing employees. It lays a marker in the sand of, look, we might be unsuccessful, but we're going to make your life difficult. If you have the cheek to try and take our clients away and our customers away, we're going to make an example of you, and we're going to pursue you hard. The other thing, the flip side to that, is it improves for the remaining employees. It improves team morale. It can be a little bit disheartening for the remaining employees if they see an ex-employee walking away with a big client or a large degree of work. It can be a bit disheartening, but actually, if you see that, well, steps are taken to correct that, it can help that. Similarly, it also sets an example to your competitors of and within the marketplace of, look, we're not going to allow you to poach our good employees or to take our customers as you like. And then I think the other thing is, and this links specifically really to the cost, because it is a big cost issue, that it is always a big concern, is the likelihood of it actually getting even to an interim. I said a final hearing, but in terms of even getting to an interim injunction stage, that the statistic that I always give clients is over 20 plus years of dealing with these things, I think I've either sent out or been on the receiving end of letters before action, certainly well into the hundreds, is the amount of times I deal with that. In terms of the amount of times it's gone to court, I think I can count on, if not one hand, then certainly two hands, the amount of times that it does. So, and part of that, it links to the level of costs, is you have to be kind of fairly convinced of both sides have to be prepared to spend a lot of money in order to deal with this. And actually, again, what you have to bear in mind, I know we talk about the costs and you may see that from a negative perspective, but actually it applies equally to the ex-employee. Is the ex-employee has to start instructing solicitors, start thinking about, well, how am I going to fund this, and how am I going to be able to deal with it? So I think, as I say, it is a balancing point, but it is worthwhile bearing in mind. So with that, I think that pretty much brings it to the end. Does anybody have any questions at this stage for either Nick or I? I'm sure Nick would be more than happy.
Thanks, Gordon. I've been monitoring the Q&A and the chat and can't see any so far, but if anybody does have any, we do have some time for those.
No.
That's also fine.
I was going to say, it clearly from the quick fire round, everyone was getting it right anyway. So it's all good. It's all good. Well, look, if there is anything, obviously you've got Nick and my details, so please feel free to message us directly. Nick, do you want to?
Yes, yeah, absolutely. So just to finish, thanks, Gordon. That was great. A few things that we just wanted to highlight to you. So we are doing at the moment, a free employment contract and employee handbook review. So COVID kind of got in the way of some of the stuff that clients have needed to get into employment contracts, not just restricted covenants, but other things on the back of what was called the Good Work Plan. And we're actually seeing a lot of clients looking at reviewing contracts in particular to make sure that they're legally compliant and to make sure that they're as robust as possible. Now, on the back of this session, we've also said that we'd give you a view on your post-termination restrictions, because it seemed to make sense to do that and not to exclude that. So if you do have concerns about that and whether they might work, whether they look good, whether your contracts are legally compliant in other ways, we'd be happy to have a look at those. We're also seeing a huge increase actually in online training and in-person training for clients wanting to upskill managers. So we're doing a range of kind of training days for clients. I think the majority actually in person at their premises, covering things like employment tribunals, discrimination, bullying, harassment, managing disciplinaries, grievances, absence management, that kind of thing. So if that is of interest, we can help with that. If you're an HR professional, as most of you are, hopefully you've already heard about the East Midlands HR Network. That's something that we founded, I think, nearly 7 years ago with a couple of other organisations, entirely devoted to sharing best practice between HR people. We have an event coming up with the Coal Authority on diversity. We're going to be pushing that much harder now. In terms of advertising that. That's next month, so please look out for the details of that. And the other thing I wanted to trail is something called the HRD Talks, which is a podcast series that we're hoping to launch. We have a number of HR directors lined up who I'm hoping to interview and again get some really interesting insights from them that they're willing to share. And then finally, our next webinar. So I think this is the third in the series that we've been running sort of post-COVID. And obviously, we're seeing some significant economic issues in terms of downturns, recession, that kind of thing. And actually, a lot of clients are coming to us and saying we need to right size our business, I suppose. So it's not just redundancies, as in losing people. Often it's restructuring in a way that is fitting for what's to come and the challenges that a lot of clients have been through. And again, that session will be a very similar one to this in format, in the sense that it will be on Teams, and we will be advertising that in more detail. The other thing I would say, if you've enjoyed the session, and we do spend a lot of time advertising these on LinkedIn, please feel free to comment on any of those posts or share any feedback there. That would be great. And we're obviously keen to encourage people to come and join us in the future as well at the events that we're holding online. So I haven't seen any other questions appear while I've been talking. So I think it's just a case of saying thank you very much for joining us, and we hope you've found it useful, and we'll see you next time. Thanks, everybody.